Perfect. I look right as my printer kicked on to make noise. Sorry about that.
It's okay. Hello, everyone. My name is Susan Kim. I'm the director of the Family Justice Center and also the lead of the Family Justice Institute. You are attending our, I don't know, 6th or 7th institute training. Every year, we offer free workshops to our community on topics related to interpersonal violence. Today, Friday, first of all, happy Friday. We have the pleasure of bringing our Deputy District Attorney, Adam Wilkes. And Adam actually sits right here in Richmond at the West Family Justice Center. That's where he's located. And we can find him anytime we need to talk to a Deputy DA. That's a really great thing that we have here at the Family Justice Center. And he's gonna talk about this important topic of child abuse and child abduction, which is also child abuse. Right, Adam? So
yes,
it's all yours now.
All right, fantastic. Before I begin, if I can just take one moment, I just want to make sure that I have a timer running. All right, thank you. And so, Susan, I'll just kind of give you the sign for next slide. And good afternoon, everyone. So my name is Adam Wilkes. I'm a Deputy District Attorney in Contra Costa County. I am currently assigned at our office's Family Justice Center. I handle domestic violence cases at the felony level, and intimate partner violence cases. And previously, until just a very short while ago, I was head of the office's child abduction unit. So that's going to be the nature of our training today. We have 3 goals today, which is 1, being able to identify and legally identify child abduction, and then discuss how child abduction is investigated, reported, and addressed. And then we're going to be talking about a broad concept of the good cause report, or a concept that winds up coming into play in domestic or intrastate child abduction cases. So next slide. And we'll start off with our first question then, which is, what is child abduction if we were going to work from a definition? So first, a lot of people think child abduction, and the first thought or image that comes to our mind is somebody grabbing a child off the street, and usually a stranger. In reality, if I get next slide, most child abduction that we deal with, and most child abduction that is reported in California and nationally, involves a child being abducted by a parent or a close family member, someone with whom the child has a pre-existing relationship. If I get the next slide. That's backed up by statistics that kind of bear out over time. If I can just hit one more, hit next. You can see that for our 2021 stats, the statistics of stranger abductions, which is our 4th from the top, versus the immediately following row of parental abductions. About 1,500 parental child abductions in the year 2021 versus 37 as reported by strangers, or reported as against strangers. So let's move forward, next slide. And let's get then a good working definition of what child abduction actually is. And I'll turn first to the law. And if you were to look in the California Penal Code, and if you were to look in what we call the CalCrims, what does a prosecutor need to prove that the crime of child abduction has taken place? You'd see a definition that looks like this. I'm putting up this not for its informational value, but just to kind of show you, boy, that looks like a lot of words. So we should probably put that into plain English. If I get the next slide, we're working from Penal Code sections 277 and 278. And I've highlighted there in the middle sort of the important part, or the part that I'd want you to focus on, all of this kind of legalese and a lot of this text. It's depriving someone of a lawful right of custody. So if you look at the next slide, that's what we're talking about. When we talk about child abduction broadly, we are talking about not just forcible child abduction, not just kidnapping, not just child abduction for a sexual motive, or child abduction done for the purposes of harming a child, but also encompassing child abduction that violates the legal rights of a parent, guardian, or a person with a right of custody or visitation. This is in recognition of the idea that a child has the legal right to the full participation of the parents and guardians in their life. especially if a judge has recognized or decreed or ordered that a child has a right of custody or visitation with one parent. The law recognizes that to deprive a child of that right, that itself is a legal wrong. So if we move forward, if I get the next slide, I guess that brings up big questions. If you have a set of facts, or if you have a circumstance that comes before you where a child goes along willingly, where a child says that, you know, the parent who took this child in violation of a court order, or a parent took the kid away from one other parent, what if the parent who's done the taking says, well, the child actually wants to go with the abducting parent? What does that matter? Is that legally significant? And next slide. And you can see, no, that's not the case. And here I've actually cribbed from the language of Penal Code Section 278 and the CalCrim on that point. And I'll just read it here. Somebody can be guilty of child abduction whether or not a child resists or objects, and even if a child consents to go along with somebody who's taken them. So, well, what about parents where we just have a visitation schedule? What if we have, and you can hit the next slide, thank you. Can you take me back one, Susan? Sorry about that. All right. Well, how about parents who maybe have a right of visitation, only have a child on the weekend, where one child has, let's say, an 80% custody order versus a parent who has 20%? Well, what does the law make of a distinction as between when a parent with 80% of child custody takes the child from the parent who only has 20% visitation, 20% custody or a right of visitation, right? What you'll see is that legally that is insignificant for the reasons that I've already highlighted. It's any right of custody or visitation to deprive a parent of that right and to deprive a child of that right of visitation. That itself constitutes child abduction. So when you see these cases come across your desk, when you see these sets of facts described by people, that's what we're talking about. So thank you, Susan, moving ahead for me, appreciate it. So I'd like now to talk, and we're going to be framing our discussion by talking about the statutes, the laws, and the rules that govern child abduction in California, nationally, and internationally. And so we'll start off with our reference to the California Penal Code. And here's a few statutes that we see or come up the most often, those being Penal Code Sections 278 and 278.5 for child abduction. Kidnapping is 207, that is forcible kidnapping, meaning taking a child by force or fear, or taking an unresisting child for an illegal purpose, or violations of Penal Code Section 166, which is what we see when we have somebody who violates a domestic violence restraining order that oftentimes deals with custody or welfare of a child. And so if we can get the next slide. I do want to talk a little bit then about kidnapping. These tend to come up less than 278 and 278.5s because when we're dealing with a parent who is doing the abducting, or the parent who is the person who is taking custody of a child in violation of a court order, Penal Code Section 278.5 specifically deals with those circumstances in which someone has a right of custody and where we're dealing with a non-forcible taking. Also for Penal Code Section 278, again, like I said, whether or not the child resisted, even if the child consented to the taking, those are factors that have different legal analysis for what we think of as straight up kidnapping. And moving forward. And again, DVROs, you'll see these come up a lot in contexts in which a domestic violence restraining order is granted. And as part of that domestic violence restraining order, you will see issued a schedule for the safe exchange of children, or a reference to an addendum on a domestic violence restraining order related to child custody. That's when we'll file Penal Code Section 166 violations, in addition to 278 or 278.5 potentially. The things to know for our purposes, the first three statutes I've talked about, child abduction, parental child abduction, kidnapping, those are felonies. Penal Code Section 166 is a misdemeanor. All right, and if I can get the next slide. I'd like to talk to you then a little bit about how federal law comes into play and the what is called the Uniform Child Custody Jurisdiction and Enforcement Act. And that has specific play in California through California Family Code Section 3130. And that's where the role of the prosecutor changes a little bit than just being the person who's responsible for prosecuting crimes. So if I can get the next slide. All right, I'm going to start off with a hypothetical question to the group. And if people want to maybe pop in some answers in the chat as we're going along, happy to hear your thoughts. So let's suppose that we have a child that lives with their parents, lives in the state of New Jersey from birth until the age of 5. Well, what would happen if, let's say, the mother takes the child to California and immediately upon arriving in California files for full custody? All right, I guess there are the questions that would sort of come up for people, or as I guess we would say in my house, your ears would kind of go up for a situation like that. And why? Well, first, it seems like that would be a circumstance that's ripe with abuse. A parent would then have the right to go to a place where they've had no prior connection, a place where the other parent might not even know where they are, and then get full custody of a child without the say-so or involvement of the other party. And that's the kind of abuse that the UCC-JEA is intended to discourage. So if we move forward, next slide. All right, the UCC-JEA requires that a court that is hearing a petition to determine child custody. I'm sorry, before I move forward, there was an interesting question just came from Tatiana. Would marriage be a factor? If the couple is unmarried, would it still be an issue? No. Under California law, and actually no, under laws of all 50 states, married or unmarried, that would not be a factor. But the UCC-JEA says, well, you can't just go into any state and immediately file for child custody just on the basis of you bringing a child into that state. So thinking about our prior example, one parent taking their kid, going to another state, and without the consent or even knowledge of the other party saying, oh, by the way, I now have full custody of this child, right? We can imagine the legal abuse and the abuse of the other parent that would be endemic if we allowed that to happen. So a court that's hearing a child custody petition has to make a determination under the UCC-JEA of, one, does this state even have jurisdiction to decide child custody? And we'll think about this in terms of order of priority, meaning which state has the right to determine child custody. Well, the first state is going to be what we would call the home state, meaning if all the parents say live in California, all live in one state, nobody's gone anywhere else, well, obviously that would be the place where child custody gets decided. That would be the place where it would be appropriate to bring an action in a court in that particular state. Moving forward to the next slide. Well, but what about our scenario where the two parents have lived separately, one parent has the child and takes that child to another state? What then? Well, this is where 6 months winds up being an incredibly significant period of time. If you are dealing with potential child custody issues for cases of interstate, meaning somebody taking a child out of state custody. Because if everybody doesn't live in the same state, then within 6 months of the child being taken out of state, the appropriate place for the child custody petition to be heard would be the state where the child was living before the 6 months of the abduction. Meaning, in our last example, when we were talking about mom and dad living in New Jersey, mom moves to California, after a month says, I'm filing for full custody. No, the UCC-JEA would say it is not appropriate to hear that matter, and California does not have jurisdiction. Jurisdiction would be appropriate in the state of New Jersey. So, moving forward to situation number 3, next slide. All right, well, let's suppose that we don't have either state would qualify. This could happen if parents are moving, if you have parents that are parents are staying in two separate states and a child is in a third location. Well, then we would have a state where the child and at least one parent have what would be a significant connection. And for our purposes, when we talk about a significant connection, that'd be either born there or living there. Think of somebody having a driver's license, somebody having a residence, that would probably qualify. And then if none of those qualify, there is a catch-all provision that you kind of rarely see, and on the next slide, which is for any state. Basically, if you can't figure out where the parties should be, then any any judge just basically needs to get involved and start figuring it out. So if there's no other qualifying place, then any state would qualify. And if we can get the next slide. All right. So now moving forward to our example, I've changed it a little bit on this slide. All right, child's living with mom and dad from birth to age 5. Mom leaves for California, files for full custody in California after 6 months. Well, this is where that 6-month window really matters, because the 6 months becomes legally significant for where a court could actually hear a child custody petition, meaning dad still in New Jersey now finds himself in the position of having to defend, argue, and participate in a child custody hearing on the other side of the country, potentially with somebody who took their child without permission, without their consent. So we can imagine in this circumstance, if a child has gone missing from one parent versus another, and one parent has not given permission for the other parent to take the child out of state, well, if you have this 6-month period of time, it becomes very important that that child be located and that we have some means of ensuring that at least a court is going to be able to get involved. So if you can show on the next slide, and if I can get the next slide there. This is where I made reference to California Family Code section 3130. And this is where the Office of the District Attorney and a prosecutor's office gets involved. And that's because, if we can get on the next slide. Again, a lot of text there, but moving forward, let me put that into plain English. Next slide. 3130 in English says that if a court has jurisdiction to hear a child custody petition, but either we can't find a child or there's a risk that the child is going to be concealed, then, next slide, you can see that the DA's office is supposed to step in, take all appropriate steps to locate the child and ensure compliance with whatever court orders are going to be issued. And if you move forward, that's where we talk about what's called a locate, serve, and recover order. And that is pursuant to, if I can back it up 1 second, that's pursuant to California Family Code section 3131. Where you will see this come into play is if you were to have a parent who's in California, let's go through this. I'm going to play out a hypothetical that we see in this office that maybe some folks in the room have encountered themselves. Imagine 2 parents. Father leaves with child, takes the child to Florida. Child left the state, let's say 3 or 4 weeks ago, right? Well, if we're talking to the left behind parent, that left behind parent is probably really scared and really worried right now and thinking, am I ever going to see my kid again? Well, the advantage is, let's say that in this scenario, there's never been a divorce decree. There's never been an order regarding visitation or custody in California. Let's suppose that the parties just got divorced a few weeks ago or a few weeks before the kid went missing. Well, what then? Because in that scenario, it seems like you'd be saying, well, there's no child custody order in place. You probably should have gotten that when the two of you decided to split up, but that's not the way the world really works. So what you would say instead is, all right, what we need to do is contact the district attorney's office in the county where the child was living and file under Family Code section 3131 for a locate, serve, and recover order. Because under the set of facts that I just worked with, child is taken by dad, and within 3 weeks of the report to you, goes missing and is taken by dad to California. Mom comes to you and says, I need your help. Well, the advantage for us is that the place that's appropriate to bring a child custody petition becomes California, right? Because it's been less than 6 months since the kid went to Florida. That 6-month window being really legally significant. So because we have less time than that, we instead file for a petition in California. And as part of that petition, you would seek the district attorney's office's help under Family Code Section 3131 in obtaining a locate, serve, and recover order. All right. And I'll take a moment before I move forward because I realize that's a lot of information. All right, somebody just popped in with a question, and I'm happy to take questions on this topic at this time.
So this person says, I have often seen cases where one parent moves out of the state with the kid to live with grandparents who could support that parent and the children. And the other parent initially agrees to the move. And then 6 months later, the parent with the kids in the new state ends up filing against the left behind parent, and the left behind parent just kind of seems out of luck. They're asking, is this correct since the left behind parent initially agreed and never established a custody arrangement?
Great question. All right, so there's a couple of different legal questions that are on the table there. Because one is, what's the ultimate outcome of the child custody court's determination? And so what I'll say is, and I'm trying to decide whether I should treat this like, what's the guy who teaches like he teaches calculus on YouTube? I'm trying to decide whether I should do it like that. I don't know that that's going to be the right idea, but my desire to do that is really high right now. So there's two separate legal issues because one, you're talking about consent. And sorry, I jacked my hand up while mountain biking the other day, so apologies. So we have consent with a 6-month window. So these are two different things. And was that even helpful at all? Can people actually read that? All right, Susan's giving me the,
You're good.
thumbs up.
You're good.
Thank you. All right. So let's say for that 6-month period of time, there is no child custody determination. All right, we just have the informal cell phone calls, the agreement of, all right, we're going to go stay in New York, leaving from California. We're going to stay with grandparents because maybe it's a better environment for our child at this time. Okay, that consent or that initial consent is not legally binding. A parent making a decision or trying to kind of feel out like what's the best interest of my child, like what's in my child's best interest, that doesn't mean that they're bound forever and can't seek recourse in court and can't get custody of their child later on. But what is significant is the 6-month window. So if we're dealing with less than 6 months, this is where your obligation, either as a navigator, as an advocate, as a prosecutor, you need to explain to people that their legal rights regarding the jurisdiction of where that child custody petition is going to be heard, that 6-month window is legally vital. Because otherwise, you know, in kind of the New Jersey situation, all of a sudden you're a California resident and there's a court on the other side of the country that's deciding with, you know, all the witnesses and the parent and the child over in New Jersey, where this other parent isn't, deciding whether or not it's appropriate for the child to stay in New Jersey permanently, or what kind of custody or visitation should be appropriate for our California parent. Now, consent is going to wind up being significant or relevant for whatever the underlying merits are of the child custody hearing. So once the court has jurisdiction to hear the petition, so let's say in our situation, it's more than 6 months. They left California, they're in New Jersey. And I'm using New Jersey as the example because it's on the other side of the country. It seems very inconvenient to get there. Well, of course, then when a court decides issues of child custody, you are going to be looking at what is called a best interest analysis. And one of the factors the court is going to consider in that best interest analysis is, hey, did the other parent consent to this? Did the other parent agree that this was in the child's best interest? It's very likely that that consent is something that would be relied upon for whatever judge winds up determining the issue. But the problem here is this is not a legal issue that you necessarily want your California client or the person you're working with, the victim of child, the victim parent to be addressing. You don't want them to have to fight on the underlying merits of a best interest analysis or a child custody petition. You're in a much better position if you can explain that somebody's rights are going to be legally impacted if the child is taken out of state and has been out of state for more than 6 months. That's why it becomes vital that under sections 3130 and 31, that you either get a petition in the state of California and that you obtain a locate, serve, and recover order from the district attorney's office of the county where you file for a child custody petition in California. Hopefully that makes sense. And if there's been other questions that popped into the chat, I'm all ears. Or all
There was
eyes.
there was one more, but Lynette dropped off for a minute. She had issues with Wi-Fi. So she's saying, what if a mother is running away from her exploiter, who is the father of the child, and they don't have a court-ordered custody agreement in place?
Okay.
But the same issue, that would still apply, right?
Yeah, so, and again, that goes towards an issue of what we deal with when we're actually dealing with a judge that's hearing a child custody petition. When we're hearing a child custody petition, then we get back to what we call the best interest analysis. And the best interest analysis is where you as a navigator, as an advocate, or as a prosecutor need to help that person marshal evidence that this is, that the exploitation was going on, evidence that this person was being trafficked, evidence of domestic abuse. So photos, the text message, text thread log, things like that. Because all of that winds up being relevant towards who ultimately gets child custody and of what amount. Does this person have a right to visitation or only to supervised visitation? But what I'm talking about is the issue that only specifically comes up when one parent takes another child out of state, because the legal issues that change there are significant, separate and apart from, we can imagine if somebody is fleeing their exploiter or doesn't want their exploiter to have access to their child anymore. We would hope that the victim that we're working with files for child custody or files a petition to get full custody of the kid. And the legal issues that come into play there in California, they're going to be the same whether or not they're here, whether or not they're out of state. What I'm trying to specifically guard against, and what I want to make sure that practitioners are really clear on, is that 6-month window is going to be really significant if you have a left behind parent and an abusive parent takes a kid out of state, moves to another place. That will have legal ramifications that are significant and permanent for that 6-month window. And hopefully, I hope I'm making that really clear. So thank you. All right. And if there aren't any other questions, I then want to move on and talk about not just children being moved from one state to another, but now I want to shift gears. And I want to talk a little bit about international law and children being moved from one country to another. And this is where we get into what is called the Hague Convention. And if you talk to an attorney who works in the child abduction unit of a DA's office, you're going to talk about a Hague Convention case. If you talk to a child abduction investigator, they're probably going to be familiar with that term. The full title is the Hague Convention on the Civil Aspects of International Child Abduction. But what we're more dealing with are two scenarios. One in which people are in the United States and one parent takes a child out of the United States to live permanently. The other being where we have parents that are outside the United States and the parent and child move to the United States, and the left behind parent in another country is saying, hey, what about me? What about my child? What about my right of custody to my child? So I can take just a moment. All right, let's move forward one slide. Okay, so here's a very straightforward example. Child lives in Guatemala with mom and dad from birth to age 5. Dad leaves for Guatemala, or sorry, I apologize. That should say dad leaves for the United States with the child. I apologize. So now father is in the United States and has a child, or has the child, and mom is now still in Guatemala. Well, what happens then, right? If we're in that position, if we're in that circumstance, does mom have any legal recourse, and how? And what you'll see is that this is where countries that are signatories to the Hague Convention have an agreement that the Department of State or its equivalent in each country will work to cooperate so that way we can have a petition filed, and what's called a Hague Petition filed in the court of the jurisdiction where the child is now located to make a determination about whether or not the child should stay in the country where the child has been moved to, or should go back to the country of residence or prior residence. So in our example, if we have a child that lives with mom and dad in Guatemala until age of 5, and then dad leaves for, not Guatemala, leaves for the United States with the child, our circumstances then would be, mom could then go to the Department of State in Guatemala or the state consulate in Guatemala and would file or seek the assistance of a state signatory, a state advocate there in filing for a Hague petition for the return of the child. And this is where the district attorney's office comes into play. This is where our role comes in trying to essentially run what's called a Hague hearing. Now, before we move on, I'll get next slide. I want you to note that when we're dealing with international child abduction, the hearing and the Hague petition is really limited in its scope. So really all we're looking at is, was the child wrongfully removed from the country in violation of the laws or in violation of the rights of one parent or another? So in our Guatemala example, both parents, unless there's another court order, you'll find that most countries say that parents have a right to full custody of their children. Meaning, if I have a child, whether or not I'm married, whether or not I'm divorced, whether or not we're living under the same roof, I still have a right of custody to my child just by virtue of the fact that I'm the biological parent of that child, unless and until a court order changes it. Does that make sense to everybody? And this is where if we were all in a room together, I'd be looking for nods, but I'm in Zoom, and so I can't get that. So I'm just gonna have to look in the right-hand side. Thank you. Somebody just typed in, yes, thank you. And I want to say thank you to you. That was very helpful. You're making my day, Christina Fuentes. Thank you. All right, appreciate it. So what we're doing in that scenario is asking a court where the child is now located to look at the laws of the country where the child was living and essentially to make a determination. Hey, were the rights of the other parent, who we'll call the left behind parent, were those rights violated? And that's about the only determination the court is really making. That's the determination that governs whether or not the child is going to be returned. So I'll give you a clear example. When we have parents in Guatemala and parents one parent moves to the United States. Let's say it's dad takes child to the US. Well, the court in the United States, as a Hague signatory, doesn't engage in what's called a best interest analysis, meaning the court doesn't now say, well, I think that it's better if this child lives in the United States because I think the US is a great country. I think that the child might have better access to education in the US. I think our school system might wind up being better. I think the child might have better prospects in America. That is not the legal issue on the table in a Hague petition. So understand that just like we wouldn't want, imagine if we had France or another country in Europe. Imagine if they said, well, all right, a child was taken from the US by one parent. Mom takes the kid to France. We wouldn't want a court in France saying, well, you know, if that child is in the United States, there's a lot of firearms in the United States. And, you know, the risk of highway accidents, the rates of childhood obesity, I'm not sending that kid back to America. Nope, way better over here, right? That sounds crazy. That sounds unconscionable, and we wouldn't want courts engaging in that kind of analysis. And that's the same instinct, or that's the same sort of legal drive that we have to use in a Hague petition to say, look, we're not engaging in a best interest analysis of which country are we rooting for, which country do we like better. Instead, we look at the rights of the parents, and that's where a Hague petition starts and stops. Except, because I'm a lawyer, so of course this is where I have to say, well, that's true, but most of the time, except, and if I get the next slide, except the court engages in two kinds of analyses, and one of them is what's called a grave risk analysis. And that is where a child will be subject to physical or psychological harm or otherwise be placed in what a court would call an intolerable situation. And let's move forward to the next slide, because you'll see how this really comes up for us. Oops, sorry. If I can actually, let me go back one, apologies. All right. So for our grave risk analysis, one of the things to understand is that specifically we have risk of physical or psychological harm. And what courts have concluded is that that specifically includes a child being witness to or around domestic violence on the part of one parent upon the other. So where we see this come up often is two parents living in a state outside of the US, meaning living in, let's say, like Lithuania. One parent leaves. Mom leaves under circumstances in which she has reported domestic violence, in which she now takes her kid fleeing domestic violence and takes her child to the United States. One of the analyses that a court will engage in is what's called the grave risk analysis, which means, was the child, or would the child be subject to physical or psychological harm or otherwise be placed in an intolerable situation by virtue of their exposure to domestic violence or putting them back with an abusive parent? Now, the tough thing for claimants or people who are trying to use the grave risk analysis to try and make sure that the child doesn't get returned to the country of origin is that that has to be proven by what's called clear and convincing evidence. It's a standard that is just below proof beyond a reasonable doubt. Now, I've seen that standard met my time in the child abduction unit, but it doesn't happen often, and it's not a guaranteed thing. If you are working with either a victim, if you're working with somebody either as a navigator or as an advocate, you're talking to somebody who is fleeing from another country, has come here, and is now the taking parent in a Hague petition case. This is where it's going to be important to work with them to establish things like, hey, do you have any cell phone pictures of physical violence? Meaning, you know, like, do you have any pictures of bruises, injuries? Yeah, photos maybe that you sent to other family members. Do you have text messages involving statements that the person, the left behind parent, made about either admitting or confessing to abuse or making threats to the person who fled? So there is another component or a component that comes up less often, and that is under Hague Convention Article 12. I didn't put a slide for this because it comes up somewhat infrequently, which is if you have stayed for over a year in the country, there is a presumption that a child has been well settled or maybe well settled in their new environment. However, that tends to not come up as much because you'll find that most parents who file for a right of return under the Hague Convention are doing so within a year. It is a rare case in which people let their child go to another country without their consent and then sit on their rights for a year, and after, say, 2 years or longer, then say, you know what, I would like my kid back. So we don't see that as often. That does come up, but it is just not as frequent. And in that situation, there are other defenses like consent that wind up being relevant to whether or not the other parent even consented to the child going to the US in the first place. All right, so if I can get to the next slide. When we deal with Hague Convention cases, this is where I'd like you to understand the role of the district attorney. So when one of these cases comes to us, either as what we would call an incoming Hague case, meaning child and taking parent coming to the United States, or an outgoing case, meaning child and taking parent leaving the US and going somewhere else, the first job of the prosecutor is to communicate with the US State Department. Oh, I'm so sorry. I didn't realize that there were questions, but thank you so much, Natalie. I appreciate it.
You're okay. I'm going to let
Great.
you go and then I'll jump in.
Awesome, thank you. So the first role of the prosecutor is to communicate with the State Department and gather materials from the California Attorney General and the State Department. Usually that's going to mean gathering Hague Petition materials that come to us from another country. What you'll see are the statutes and the applications that get written in a native language, translated into English, along with photographic evidence to show, all right, well, who are the parties that we're dealing with? Enough information that you could put together an order by a court, a photograph that an investigator could look to say, hey, this is the child that I'm looking for. Also, our role is then to get the parties all into one place, knowing that we're going to be having the other parent in another country is going to be appearing either telephonically or now by Zoom. We arrange the hearings, and we're also responsible for questioning witnesses, meaning the court doesn't do the questioning itself. So it's the district attorney that presents evidence or asks the questions of, hey, when did your child first go missing? When did you first suspect your child go missing? When was the first time somebody told you that they were going to take your child out of the out of Guatemala, out of Lithuania, and take your kid to the United States? And then asking questions or gathering evidence to establish potential Article 12 or Article 13B defenses. And an inspector for the district attorney's office, in our case, it's a man by the name of Rick Rivera. Inspector Rivera is responsible for ensuring that if a child is transported from the US to another country to be back with another parent, is responsible for transporting children. So I'm going to take a pause here and let me answer some questions, which I understand could have kind of come up in the chat.
Yeah. So
Thank
one
you.
question from Harry, who is with our Lawyers for Family Justice. I'm going to preface this by saying Harry is our best legal researcher. So he's questioning you.
All right, outstanding. Let me hear it. What do we have?
So he gives an example that mother and father both live in Contra Costa County.
Okay.
There is no custody order in place. Father takes one-year-old daughter from the home they previously shared, and mother does not want him to take daughter, but he does. Under Penal Code 278.5, is mother a lawful custodian? Is father a lawful custodian?
Yes. So this is, I'm assuming, the biological child of both parents.
Yes.
There's no child custody order in place. Does not matter, not legally significant. If it's your child, you don't need a court order that says, hey, by the way, you have custody over that kid. So by virtue of your parentage, however you could establish it, whether it's presumed, whether it's on a birth certificate, but yes, you are the custodial parent of that child for purposes of 278.5. Great question. Thank you for making sure that we're all on the same page on that.
And then I think you answered this already, but just to confirm, the good cause report petition can be filed with Rick Rivera in your office, right? I
really appreciate that somebody knows where we're going next, because we are about to talk about good cause reports.
Oh, great.
Yeah, you're about to hear more about good cause reports than you want to know. So let's, if I can, that's actually exactly where I'm going next. If that's
that was it.
Perfect. All right, so California law and parental child abduction. Let's start off with our next slide, and here's our big picture, which is parents don't get to decide for themselves whether or not we follow court orders, right? So moving forward. All right, we see this very often, and I'll speak for myself and Mr. Sanso of the DA's office, who's also here. You will sometimes see cases that come in. One parent calls a police agency, non-emergency line, I hope, and officer comes out, takes a report. Well, we have a child custody agreement and I'm not sending my kid over to that house. Why? And I use this example, I am not kidding. Well, dad doesn't make our child brush their teeth, so I'm not sending them overnight. Can you imagine what our dental bills are going to be like? Right? That is not a reason for you not to follow a court order. Now, that is a reason. I'll answer that question later. That is a reason to potentially bring it up with a child custody, the judge who is deciding the child custody order, the judge who is presiding over a case involving the custody of the children at the next hearing. It is not a legal justification for saying, I'm not turning over the kid, period. Next slide, if I can. All right, same thing. Well, our child went over for the weekend. There was a book report that was due last week. Our child doesn't do book reports. Instead, the other parent is just letting them play video games so that way I'm the bad guy. And as a result, I can't put up with this anymore because it makes my job as a parent difficult and intolerable. I'm not sending my kid over. And then you have the other parent makes a police report. That is not sufficient. And in fact, that is a scenario in which that parent, if we look back at our definition for Penal Code Section 278.5, what has this parent done when they say, hey, my kid's not doing homework when they go over for the weekend? So I am confining my child here. I am depriving the other parent of a court order that says that that parent has a right of custody and visitation for the weekend. But I'm not going to comply with that because I don't think that they're pushing our kid hard enough in terms of homework, right? The parent who's keeping the child from the other parents in that scenario, even let's assume the best intentions. Let's assume that, all right, yeah, video games, they are actually making it hard for you to be a parent. The other parent is kind of making you into the bad guy. Doesn't matter. You're still actually guilty in that scenario of a felony under Penal Code Section 278.5. Well, let's move to the next slide. Right? Now we can see something rings a little bit differently and our spider senses are kind of tingling with these two, right? All of a sudden, now we're not talking about teeth brushing. Now we're not talking about whether or not the book report gets done. Now we're talking about things that are scary. And this is where we get into what is called a good cause report. We can go to the next slide. All right. So, like I said before, any deprivation, meaning dad has custody for the weekend, mom keeps the kid because of brushing the teeth or because of the book reports. All right, mom is guilty of a felony in that scenario. She does not comply with a court order. But let's move forward. Except, because again, I'm a lawyer, there's always going to be an except for everything that I tell you. Except in cases in which the concealing parent is doing so because they, in good faith and reasonably, are fearing domestic violence, physical violence, or significant emotional harm. And that's what's called good cause to keep the child from the other parent. Well, that sounds really easy. And that sounds sort of like almost kind of loosey-goosey, because then the parent who's keeping the child, well, it almost sounds like they get to decide for themselves whether or not they want to follow the law, because any parent could then say, well, I am afraid that the child's going to be subject to emotional harm. And here's why. Well, there's actually legal qualifications that a parent would have to go to, and that's what's called a good cause report. Next slide, please. And that means that you are required as a concealing parent to notify the district attorney's office. And the statute deals with or states in the county where the child was living, what you should think of is usually it's going to be where the court order is in effect, is probably going to be the place where you actually file the good cause report. That means if you are a concealing parent and you are concealing the child because of fears of domestic violence, it is your obligation to contact the district attorney's office and explain it. More details on the next slide. And here are our qualifications, or here are the specific rubric that you have to go with. It means that if you're dealing with someone who comes to you and says, hey, there's a child court order in place, I am violating that order. I get it that I'm supposed to turn my kid over for the weekend, this next coming weekend, and I'm not doing it. And here's why. All right, if they explain to you it's because of domestic violence, it's because of fears that the child is going to be physically harmed, if it's because of a significant threat to that child's safety or to the safety of the other parent, that means that you have 10 days from the time that the concealing parent actually doesn't turn over the kid, meaning from that day in which, let's say, dad is entitled to have the child at 10 a.m. on Saturday. If it's 10 a.m. on Saturday, that starts the clock. Our concealing parent has 10 days from that Saturday at 10 a.m. in which to file a report with the district attorney's office that gives their name, current address, phone number, updated contact info, and lists all the reasons why the parent is not turning the child over. And then from that, still from that like Saturday at 10 a.m., from the time that they first deprive the other parent of their rights under a court order, within 30 days, you have to then commence a custody proceeding in light of the concerns that the parent has. Meaning you can't just say, well, I'm not following that order and I'm just going to file a good cause report. No. You actually have to take the affirmative next step of then going into a judge and explaining it in front of a judge and allowing a judge to then hear evidence and make a further determination about appropriate custody orders. Next slide, please. All right. Well, so you can see that we talked about immediate bodily harm or bodily injury or emotional harm. And if you see the next slide, there's specifically a statutory provision that states that emotional harm includes, for our purposes, having a parent who has committed domestic violence against the parent who is taking the child away, or the child who is concealing, or the parent who is concealing the child. So this covers our exact scenario that we're talking about. That's why this statute talks about emotional harm for good cause reports, because what we're talking about in the context of emotional harm is specifically defined and enumerated to include one parent committing domestic violence against another, because this is the bread and butter of a good cause report. This is what we see so often. So I get next slide, please. So all the requirements, and I want to make sure that I'm following along. Thank you so much. So all of our requirements for a good cause report, if you want to look them up, or if you're working with people, you're going to be referencing 278.7 in the Penal Code. And per subdivision E, when you talk to victims, they need to understand the report that they make to the district attorney's office. Hey, where are you going to be staying? What's your phone number? What's your contact information? Victims who are fleeing domestic violence in our scenario that we just outlined are going to be reticent or hesitant to turn that information over. You can explain to them that information is kept confidential and is not released unless there's a specific court order on that point. So I'm now going to, understanding that we're kind of cutting it a little bit close on time, but we've got a couple of minutes left. So with the length of time that we have, I now want to shift gears and I'd like to kind of turn it to questions if people have them. So again, my name is Adam Wilkes. If you want to contact me after this training, that is my email address. I'm happy to take your questions.
We have a couple in the chat that I can read to you.
All right,
So,
appreciate it. Thank you.
Going back to the 278.5 question,
Okay.
if there's not a court order in place, which parent has standing to file the good cause?
Great question. So wait a second, because we're talking about two different things. Because a good cause report is different than a child custody petition. A good cause report is what comes up when you are violating an existing court order and you acknowledge, hey, there's a court order that says I'm supposed to turn over my kid, right? But I'm not doing it, and here's why. Because otherwise I'd be in violation of a court order, right? So, but I think the question is, who has standing to either to bring a child custody petition? I'd say at first it's either one. Meaning either parent, either natural parent, or either person who is recognized as a parent can file for a child custody petition. If that answers your question.
I think so. MCDA, let me know if that didn't answer your question. I'll move on.
Please.
Lynette's asking, can you further explain the legal significance of the 6 months? And actually, I don't think I understand what Lynette's asking with that question. So let me bring her in real quick.
I think I understand it enough, or at least let me take a stab at it for a moment, if that's okay.
Yeah.
Which is the only change that the 6-month period has under the UCCJEA is where a court can hear a child, basically which court is going to be doing a child custody determination. And if it's less than 6 months since a child has been moved out of one state, or let's say moved out of California, if it's under 6 months, California is the place where a court should be deciding child custody issues. If it's more than 6 months since the child left California, it's whatever other state this child and their parent are now in. So that's the only, it's a really bright line standard of if it's more than 6 months, in our New Jersey example, it's going to be New Jersey. If it's under 6 months, it's California. That's the difference. Now, and it's kind of like, well, then what's the difference between one state versus another hearing the issue? Well, the problem is then you have one parent that is sometimes going to be required to make their way across the country if they can't appear telephonically. You're going to have a parent who might have difficulty in presenting the facts, or might have difficulty in presenting evidence about why they should be entitled to child custody. It's harder to defend a child custody case on the other side of the country. So it doesn't change their legal rights. It doesn't decide, hey, one parent is better than the other. But what it does is it makes it more difficult for people to enforce those legal rights. You know, if you have a parent who's in Florida and that's where the child custody case is being litigated, it is much harder if you're on the other side of the country to deal with a lawyer over there, to present evidence over there. And it's more expensive. And that has real costs for the parents involved.
Another question following up on that. If the parent is fleeing a DV situation and didn't live in the county for 6 months and can't file a good cause report, what would they be able to do to leave for safety to avoid being arrested for kidnapping? So we're talking about the victim. So say they're living in Contra Costa, the victim is taking the child and fleeing to Las Vegas.
Okay.
What should that parent be doing? Should they file a good cause report when they get to Las Vegas?
No. The first thing that they should do is they should file a child custody petition in the place where there's an existing child custody order. Meaning if there is a child custody order in California, then that's where you'd want to file. That's where you'd want to file for a change in custody. Or let's say that you leave for Las Vegas and it's been a week since you left. You know that you were living in California before, you were living in Contra Costa County before. Contra Costa County, even though you're now in Las Vegas, Contra Costa County is still the place where you would file that child custody petition initially. Now, you could make a motion to transfer it to Las Vegas for all the reasons that we've talked about. Hey, I'm fleeing domestic violence. I'm, the sole caretaker for this child. All of those reasons would be reasons to then transfer jurisdiction to a different county or to a different state. But initially, mom leaves for Vegas with the child, was in Contra Costa County, left last week. Where's the place that she files the petition? It's still in Contra Costa County, unless she's been there for more than 6 months, in which case after 6 months, she files in Vegas. Great question, by the way. That's an awesome question.
Mm-hmm. And then we have one more question. What is the consequence if the custody is not filed within 30 days after the good cause report is filed?
So the consequence is, and I'll say that it is, there's what's going to happen and there's what's legally could happen. So as a practical matter, whether or not the DA's office is going to charge someone with a crime based upon what we're talking about, that'd be hard for me to answer in the abstract, but the person is subject to prosecution under Penal Code Section 278.5, meaning if you don't follow up, and just the same thing as if within 10 days you didn't file a good cause report, you'd be subject to a 278.5 prosecution. You would legally be guilty of 278.5. Similarly, if you didn't then after 30 days file with the court in court and say, oh, and by the way, here's all the reasons why I didn't turn my kid over, and explain it to a judge, you would similarly be guilty of a 278.5. And let's think about all the reasons why that actually kind of makes sense. And the rationale behind that is, imagine a scenario in which somebody says, well, I'm not turning my child over because I'm afraid of domestic violence. Okay, well, you file that with the DA's office. You file that as part of a good cause report. 30 days go by. Well, all right, you have to file a petition with the judge. I'm not sure I want the judge to hear that. Or I'm not sure that I want to argue about whether or not that happened. Or I'm not sure that I want to present evidence of that where the other party could hear it. Now, there's some reasons why victims might be reluctant to come forward and report in that way or have that further hearing, but that is kind of a catch or a safeguard to ensure that we don't have abuse of the good cause report standard. If that makes sense.
Mm-hmm. And I think we're a little over time.
I'm so sorry, but thank you so much.
That's okay. So Adam's going to be doing another workshop on the March 18th. But if there are more questions, Adam's email, he posted on the screen, and then we're going to be sending out the slides after this, along with our evaluation. We'd love your feedback. We do read every survey to see what we can improve on and what worked well. And you're getting a whole lot of praise in the chat, Adam.
All right, well,